Welcome back. This is Newsfile, the most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And I guess right here in the studio, Victoria Bright, international corporate lawyer and entrepreneur. Kwame Boafo-Kofu has left us. Bright Simmons has also left us. Abraham Amalba is Director General of the National Road Safety Authority and is member of the NDC's Legal and Communication team. Kwabena Boateng is MP, Ejuso, and Deputy Ranking Security and Intelligence Committee of Parliament. Oliver Bakavomawo is Constitutional Rights and Policy Strategy Advisor at Democracy Hub. So I suppose you are clearly aware about what happened yesterday in respect of the OSP's invitation of Paul Adom-Okyere, former chairman of the board of the airport company. And many did not understand what exactly was going on, but he, before he honored the invitation, spoke to did a video and told the public about why he was being invited, about a contract, and then subsequently Manasseh Azure-Awene also put out a story. And this is how Manasseh Azure-Awene's story, he and his colleagues, that's Manasseh Azure-Awene, Adjoa Adobia, Owusu, and Evans Aziamo. If you recall, these are the same people who did the investigations into the SML story. So the story begins by saying 3 days before the December 2024 elections, the Ghana Airports Company Limited awarded a revenue assurance and auditing contract to Evertex Logistics Limited, a mining and stevedoring company with no prior experience in performing this service. I'm sure you are familiar with these kind of stories. With no prior experience. This shady revenue assurance and auditing contract appeared to be backdated. For evidence points to the possibility that the contract was signed after the New Patriotic Party lost the elections in 2024. The immediate past board chairman of the company, Paul Adom-Okyere, as in the Ghana Airports Company Limited, did not deny the allegation by management of the company that he brought the shady company. He has also confirmed that the procurement process for this shady contract started at the board level. The managing director of the airport company, they wrote, said the company awarded the contract to Evertex because the airport company lacked internal capacity, including personnel and time to deliver the service. Check what? However, while the airport company has 1,580 employees on its payroll, information that they obtained from the Social Security and National Insurance Trust, SNIT, indicates that Evertex has only one worker. This is where the story begins. Paul Adom-Okyere has been saying that this is witch hunt because he has been doing work against the OSP and that is not hidden, and so this is witch hunt. So let me find out from my guests, from what they have gleaned about this situation so far, what they have to say. So this time, I think I'll begin with you, Oliver.
First of all, let's be clear that Paul Adom-Okyere has been invited not in anything connecting with his journalistic practice, but in connection with the role he played as a board chairman with the company that this has come up with. We know at least from what Manasseh Azure has published that perhaps the complainant in this case is the Fourth Estate. And the Fourth Estate has done marvelous work so far in terms of some of the things that have unraveled. And so I want to commend them as well for the continuous work that they do in this regard. it is important that we understand that persons who are appointed to boards of statutory agencies are not there, well, some characterize as God's favor or whatever the reasons may be. It is a responsible and a high office or fiduciary that owes significant fiduciary duties that you are expected to perform. That in the performance of that role, you can incur criminal and even civil liability for the role that you do. Now, based on the complaints, at least on the complaint that we know now public, is the OSP entitled to invite a person who was serving there as board chair and based on the full report seems to have been instrumental in terms of bringing the company to the company, the Evertex to Airports Company? I think that the OSP is entitled to at least invite and listen to them and hear their side of the story. There's nothing irregular about the process of being so invited. And just on the basis of an invitation based on a complaint that, at least from what we have heard, discloses information that we think that some questions must be answered at least. Sorry. That anybody would then, on the basis of this, say that there's a witch hunting that's going on. So for me, I don't buy it. I think that it is significantly premature just on the basis of an invitation to then go off and try to create a media spin around this. But the work of anti-corruption agencies and of any agency is done so in the public glare. And it's done so and must expect public commentary on it. Sometimes by those who themselves have been accused in order to garner public sympathy, to be able to divert attention from the issue, or for whatever reason can be a stage to perform and get some 60 minutes of fame. I don't know what the motivation here is, but there's nothing untoward from the special prosecutor inviting anybody who a complaint has been made that concerns to come and answer questions in relation to that. If this is all the information we have, I don't think there's any more that I can say in that respect.
The story, as we're beginning to learn, as in what it is that the OSP is investigating, from perhaps the little you may have read about it, what do you have to say?
I mean, you know, the OSP has also kind of informed us that there's ongoing investigations in respect of SML. And then we are seeing, again, the tentacles of SML extend to other agencies, which is, and you know, based on the complaint investigation that has been done so far, just the sheer number of individuals that are affiliated with SML who have then transmogrified into another Evertex here, which is actually very routine in terms of how corruption happens in this country, the successive incorporation of different names to be able to do the same thing. So at the very least, it raises concern, I would say that in this particular case as well. And also reading the conversation in terms of how the procurement process was made. And we understand, and our understanding here is that there was another company, DevNest, that was going through the procurement process, and that which apparently had been cleared to be able to be procured for the service that is being talked about.
That's right.
Then all of a sudden, we have another company that is substituted to this. My understanding was that the MD was saying that it was the DevNest that was being procured that wrote to them and asked them to appoint somebody else. Again, that is completely irregular. You know, you can't go through the procurement process for another person. It's like me going for police recruitment, presenting my documents and say, don't give me the recruitment, take my brother instead. So these are things that warrant investigation, you know. And it seems now, and this is one of the biggest challenges of public auditing generally, that whether or not the need is significant, whether or not the company that is being proposed to come and do the work is being procured properly, it seems that there's a write-off that the PPA continues to give for so many of these entities. And that's a big concern as well that we need to look at. I understood that the NDC had promised that they were going to review and re-look at our PPA structure itself, concerns around sole sourcing even in general and things like that. And now one of the other approaches is restrictive tendering, which is ongoing. That I'm hoping that these things do not become just the OSP going after SML, but we are plugging the loopholes within the system that allows for these repetitive schemes to be played on the public purse and also on the public conscience.
Okay, so you catch your breath. We'll return and look at the matters that came up as far as the bail denial initially is concerned, because issues have been raised about that in respect of his fundamental human rights to be, admitted to bail. So, Abraham, again, reading the development, the stories, it looks like a bizarre story, but at this point, you're able to give the people who are, being investigated the benefit of the doubt, right?
Oh, yes, because these are just investigations and they have not been found guilty. Board members play a key role in decision making when it comes to companies, and they shape the direction the company must go. And so when I heard him say that, these are matters, these are matters within the purview of management, and they are not matters within the purview of the board, I said, no, you can't say that, because this fiduciary relationship will tie you in. And in any case, when you look at the entire story, one of it is that it has to do with the breach of the Procurement Act. Single source, some say sole sourcing, but I think the Act says single source. So a single source was given to a company, but it turned out that that company was substituted. Now the question is, have you breached the Procurement Act? Particularly, you are aware, most of the cases that have gone to the court on breach of Procurement Act are more or less like strict liability. As a board, are there means to show that the board accepted to do what has happened? You can't find that. And so he has questions to answer. He should stop hiding behind the fact that he has some bad blood between he and Kisi Ajabin, and confront the issues as they are. I'm aware that he's made a lot of publications against Kisi Ajabin, but is that why he was invited? The answer is no. It is also important that he knows that as a board member or a board chairman of the company, at any time in point, when the company is found wanting, because of the role that he has to play to ensure to protect the company's assets and protect the image of the company, he'll be invited. So this for me is not witch hunting as he claims. This for me is calling for accountability. The matters are clear. Did you engage in a single source and it turned out that another company has been granted the opportunity to do the work? That is what Paul Adumachi should focus on and deal with. This issue of he being invited because he has a bad blood with Ajabin is a red herring, it's diversionary, and it's not dealing with the substance of the case.
I'm reading this part of the story. It says that Evertex, SML's sister company, also appeared to be dormant and was resurrected only for the airport contract. Its tax record revealed that the company has zero chargeable income for 2022, 2023, and 2024, the year it won the airport contract. Evertex paid no tax in 2022 and 2023. They also checked with the Chartered Institute of Accountants, is it? And they also confirmed that this particular company has not been licensed to do revenue assurance, and that to be able to carry out this particular job, you must have been certified by the Chartered Institute. Do these make any difference for you in the?
They are huge and they are substantial. First and foremost, what's the object of that company? We are told they are not into those areas.
Yes, so we are told that it was after they got the contract
that they then decided to...
That they went to now change their objects at the Auditor General, company, Register of Companies, to include
that one.
This particular business.
So it tells you from the word go that they lack experience in that area, because if they were into that area, it would have been part of their objective. Now, the other thing too has to do with the fact that this contract was signed after the MPP lost elections, no problem about that because the directors were still in office. But it will create some suspicion about why this company, which has no experience, which was brought in later on, which invariably was incorporated later on, because that was the new incorporation, to insert in that clause for them to be able to do that work. For me, it's a new incorporation. But for that, they couldn't have
been change of objects.
Change of objects. Yes, change of objects.
So
but
that's not new
it was
incorporation.
done. It was done after the contract was signed, an afterthought. So all this will raise questions about whether the company in itself was properly placed to engage in that work. Apart from the fact that it was being favored by the way it was selected. These are matters that maybe the prosecution will use against Paul Adom Options Board. And I think that he has questions to answer, more so because of the Procurement Act, which for me was breached.
Oliver mentioned the complicity of the PPA. We find situations, many situations where when you are sole sourcing, the presupposition is that the entity you are sole sourcing is like the only one, available to do that particular job, apart from the other reasons. But you have situations repeating themselves where the entity is not in that business, they have no prior experience, and yet they are sole sourced. And the PPA continues to approve these. When it came to the SML, it was the same situation. Their very first job in this regard was the job with the government for this revenue assurance thing. And the investigations or the report suggested that they were doing zero and yet were in a position to earn because they are earning a certain percentage on the revenue that is coming in. In this case, too, it's a 15%.
PPA itself must come under tight scrutiny. And I agree that sometimes, even though there's opportunity to ratify your conduct under the PPA Act, but in a case like this, where the minimum basic requirements have not been met, which is that this company is unique and is the only company that can provide those services, that has not been met. To find the PPA okaying it, and I don't know whether in this matter they actually okayed it. I'm not sure of that. I didn't read that. But if this has been okayed by PPA, PPA itself must come under heavy scrutiny. And they may also be contributing, and that I would say contributory negligence will be applied here, where they have also contributed to some of the things that we are seeing in the breach of the Procurement Act. And they should be the last. And I think that the PPA board must also begin to look inwards and see whether some of these things that they do is helping us.
Honorable, those who did the story, they spoke to experts who reviewed the whole situation. And one of them, a foremost procurement practitioner, Obina Atabedu, and he said that the PPA and the airport company violated the public procurement law in the Evertex contract. He said Evertex was not licensed to perform an audit and revenue assurance and should have outrightly been disqualified. So he should not have been awarded the contract. This will not be the first time you are hearing things like this.
Yes, and we are all interested in matters of propriety when it comes to the governance of our country. And I come from the inclination that once you take a public office, it comes with accountability. It moves contemporaneously. And so the process is going on as it is, the invitation of the board chairman. As I sit here, I will not hasten to say that it is in a bad taste. Except that we have expectation that the procedure that we know to accompany processes like this should be adhered to. Also paying attention to, all the courtesies and rights that must be accorded to people who appear before the OSP and other.
We'll talk about that. I want us to look at what we are being apprised of as regards the substance of what is going on before we look at the question of, the invitation turned to arrest and then, the detention. Right.
Yes. So if it is as we have heard it to be, because it's an emerging story, I'm a bit hesitant in going so much to make certain emphatic, pronouncements on the merit. But we have heard, some of these comments that has come. And as I indicated, we are interested in getting to know what the issues are so that we can find solutions to them. If, issues of culpability in respect of certain individuals also emerge, then the law can, of course, take its course. I'm more particularly interested because these processes will somehow give us the role play and the dichotomy, even in terms of duties between the board and then management, because it looks like the argument that has come from both sides borders on who is in charge of what. So if I'm a board chairman, what is my role? And, as an individual within the corporate board, at what time do I inherit? At what time do I come into culpability in respect of an action that may have been taken, in that corporate, environment? And at what time can we say that, as for these things, they are within the remit of management? I'm interested in all these things. So as the issues unfold and as the OSP does its work, we will follow. More lights will be shed on these so that we can all come to, a very emphatic
When you hear
conclusion.
that the airport company's point for bringing in this company was that it lacked the internal capacity, including personnel, to be able to deliver this kind of service. And they show you their investigations that the airport company has 1,580, and this company is just one person.
That would be worrying. Conspicuously, that would be a serious issue to contend with. I will say again that it is still very early days for me to stick my neck out and make some emphatic. But as the issues unfold.
You read the Fortescue story?
Yes.
You read it?
Yes.
Okay, you saw that they attached documentation
Yes.
to it?
Yes.
Okay. You are unable to, on the basis of that story, at least make a reasonable commentary about what you think.
We all do. On the face of it, you could come to a certain conclusion of wrongdoing. Wrongdoing, the next question will be on whose part? When we find something which has been done wrong, on whose part can we affix, that blame and responsibility? The issue also has to do with times where corporate bodies may also deceive boards. That is also one angle which, comes to play. But at any point in time that we are able to clearly see that whatever was put before the board was a matter that, was clear and that nothing was hidden from the board, such that the board could have come to a wise, conclusion. But then it chose to go other way, which has occasioned some loss to the state. Then, of course, we are all interested in, affixing the blame at the right place and seeking the right recompense for the state. At this point, as citizens, as stakeholders in this country, that is what we should all be looking at.
Okay. Yes, Vicky Bright.
Yes, I'm just deeply troubled by the frequency with which our procurement laws are just, completely ignored or breached with zero consequence most of the time, and by our SOEs. And it's becoming so blasé that people kind of just ignore it. It's become like a tick box. So we need to go back to the drawing board and strengthen, our procurement body, the public procurement, the PPA, by punishing people who flout these rules. This situation that we have here, there's still an investigation going on, so we can't come to any firm conclusions. But looking at the story that the Fourth Estate has put out, it is clear that even a basic level of due diligence was just not done. I mean, the minimum was not done. It seems from the facts that we have so far that the board was ineffective and senior management made some serious mistakes. So it calls into question their competence. I don't know whether they had a board charter or not. But how can you have one company present to you and then write on the say-so of a private company that you should change the company that presented to you? You should exchange it with another company and you say, okay. I mean, who is driving who here? In colloquial parlance, we'll say, is the dog wagging the tail or the tail wagging the dog? Which is which? Because, and if that company, DevNest, is telling you that they are not competent to do the job, but then you, the board, have actually passed them as the competent company to do the board, what does that say about you? I mean, what presentation did they make that got you so convinced that these guys should not only be not shortlisted or anything, but they should actually be sole sourced? And then you have them calling your own judgment and competence into being as a board. It's serious. So who are the people on the board? Who were the people on the board? So, and then we've been through no license, and then the staffing issues, you say you don't have the capacity, yet you have 9 dedicated staff, 8 full-time and 1 national service staff. They only have 1. PPA also didn't bother going through even at the very minimum, the criteria for sole sourcing. It's very clear. It's not something that's supposed to be done in this kind of way. And then the agreement also, our understanding is that the agreement was signed without even the CVs or the employees, the would-be employees or the team members. And what the person, the DevNest guy who presented, the CEO,
right,
is also one of the people providing the. I mean, it's a total mess. So it's very troubling, and it's a real case study of.
Let me just read this portion of the story and ask you this question. The executive director for the West Africa. For the Africa Center for Energy Policy, Ben Boachi, describes the situation as bizarre. And they say that our investigations reveal that the email address on the website of Evertex evertel@ghana.com is the same as the email address on the website of Evans Timbers Limited, the parent company of SML. A search at the Office of the Registrar of Companies also revealed that SML and Evertex, the mining company that won the airport contract, have the same beneficial owner, Evans Edusei. In fact, Evans Edusei is both the CEO of SML and Evertex. He signed a contract with the Ghana Airports Company. The list of employees submitted by Evertex to the Ghana Airports Company to execute its contract contains the names of notable SML employees and managers. Apart from SML's CEO, SML's head of engineering, Hamdan Abubakar, is on the Evertex list. SML's head of IT, Prince Opoku Sapong, is also on the list to perform the Evertex contract at the airport. A former head of legal at the GRA, Philip Jude Mensah, now an SML employee, witnessed the Evertex contract with the Ghana Airports Company. He is on the Evertex list, together with a former commissioner of customs and now general manager of SML, Isaac Krensel. In essence, SML, which now appears like a post-retirement destination for top GRA employees, sneaked to the airport disguised as Evertex. How Ben Boachi's comments, he then says, it clearly tells you that they themselves, that's SML, admit that they have been doing things wrong and they don't have the confidence to go bidding or working with the same company. The question is, from the board through PPA and all other places, is it your expectation that they would have flagged the company and say, oh, you are the same person, SML, you brought us some trouble? The president, then Akufo-Addo, commissioned some, audits, and it led to termination of some of your contracts because you are not doing things well. So how is it possible that they could just go through without them being flagged?
Samson, I'm laughing because it's a joke. I mean, this is what I'm saying, that clearly the management was not competent, the board was ineffective, and there was a total breakdown. SML is taking us for a ride. We've become a huge gravy train, and they are just riding that train, from all that we see, all that we've heard about them. And it needs to be stopped. A basic, very, very, very basic level of due diligence would have uncovered. I mean, and I'm talking basic, email, just an email without even going to Registrar General. That should have triggered something. So if we are not even picking that up, then what are we doing? This is Ghana Airports Company Limited. It's a very serious organization, with all sorts of security, installations in there. For our country, it's like running, a British airport authority running Heathrow and Gatwick or something.
So how does that happen?
Wow.
Oliver, they say they have this expertise, and a journalist finds out that they completely don't have. In fact, this is not their job. It takes a journalist to check with regulatory, institutions to find that they're actually not licensed. They say they have this X number of people to do the work. They have the capacity. And it takes a journalist to check and see the checking the journalist is doing. The journalist is doing them with state authority, state agencies, and is finding at each point that they are not who they say they are. They belatedly go and now, register an object to say that we are able to do this job.
Shocking.
One of the things I find repetitive in this case, now we're interested to see whether there was a needs and assessment made by the airports company that said that we needed this revenue mobilization or revenue assurance, or that the initiative came from the company. Because you remember in the SML situation, the GRA said, no, in fact, we didn't call for this. And so there's a systemic, inorganic need generated for state agencies. When they themselves have not assessed that they need a particular help in an area, then somebody comes up with a scheme and says that we are coming to do this for you. And then that goes through a process, and then people are selected. Now, if you have in fact done any work as a company to be able to evaluate a need, you will then be able to determine, in fact, what it is you consider to have been losing in the process before you make a decision to procure. Now, even my law firm has gone on and seen tenders and applied for. The extensive number of documents that are demanded from your tax clearance certificate, labor certificate, incorporation documents, who are the shareholders, who are the beneficial owners, all this information is part of the process. This is for even when it's a competitive process, how much more when you are single sourcing the company to do this. So it is not an excuse to say, well, we should have and we failed to do, because that's also an admission of criminal liability and civil liability in some regard. But also if you tell us that you in fact received this document, then it raises significant questions about your competence for being able to hold those office. I know that certain individuals are already asking questions of the MD of the company who continues to be at post. I think that those are justified questions to be asked in the context of what we are discovering. My concern...
But the MD has terminated the contract now.
It is not enough. You see, it is not enough now that this has come into light, particularly even when there were allegations of backdating contractual documents. This would not have gone through without the MD knowing about them. So when this comes up and you say that we have terminated the contract, it doesn't
the story
cure the
says
question.
Multiple sources at the Ghana Airport Company said the board chairman, Paul Adumochiri, who had used his TV program to defend SML, brought Evertex. So are you able to see that? I don't even see how they bring him in, even if he has presided over board meetings. And how does this make him complicit? That if in fact he brought the
company in. You know, first of all, on the question of who brought the company in and the MD's role, and I'll come to this, that it is not sufficient for a board, and you are CEO now, that a board would say that we have gone to find somebody, and then we have decided this person must be awarded contract, and you would have objections to it, and those objections will not be registered. At the end of the day, the contract is signed in the name of you, the MD, or whatever is signed. So there's no excusing of liability in respect of what overwhelming role the company board played in the process. Now, if Paul brought the company in, the question of the level of influence that he exercised in influencing the getting of the contract to the person in breach of those laws is a question of scrutiny that should be done. So it's not necessarily the fact that the board chair introduced the company, but the level of influence he brought and his own involvement in the breach of laws that would have checked as to whether or not the company was better performing its functions or whether met requirements is what will be under scrutiny. Because I must say this, as a member of a board, if there's an issue that comes up in terms of how the board operates, and then you know of a company or companies that are doing particular work in an industry, you are entitled as a board to invite them to do a presentation before you for the board to make a decision. That is not the wrong or what is being questioned in this regard. The regard is the question. What is being questioned is, first of all, in fact, what he obscured or did not disclose as part of his fiduciary duties to the company, in knowing what extent of information or how do you know them. Because when I read the investigation, there was a suggestion that he had denied, in fact, being the one that brought the company to them. Again, this is based on the investigation itself. So what disclosures were made and how you got to know them and how you brought them in, it's all questions that I'm sure that would have been the interest to the OSP in this conversation.
If there's no an approval by PPA and the rest, there won't be this contract. So where is the board chair in the picture? I don't see his liability.
So this question about when the PPA comes in and approves the process, whether or not it excuses liability is also a question that we have to be able to consider to what extent. Because also, I am not certain what information was disclosed to the PPA for it to be able to obtain its approval. Those are things that I think the normal process of the investigation process as the OSP is doing would be able to clarify in what direction to be able to go.
But the PPA must also have a responsibility
absolutely.
to check to see that this company is qualified, they are who they say they are, and so on.
In fact, And it is not new in this case that the PPA itself have been involved in violations of law. In fact, we have a former PPA boss who is currently before the courts on criminal charges. But in respect of the board chair, the role that the board chair played in the process is what is being scrutinized. So it is not sufficient to say that after I did this, PPA approved. But what role you specifically played in the process to, but also with regard to the substitution of a company for another and your own disclosures that you are required by law to make.
Does it not matter that the company that gets substituted also writes a letter, and Manasseh and his friends are shown the letter that they are saying, yeah, we were supposed to do it, but we felt that somebody else should do it?
No, it doesn't matter at all. It is a different thing if the company that is procured changes its own name. Because this is in law, these are two different entities. Irrespective of the beneficial ownership or whatever it is, that other company must go through the same scrutiny and process. Whether or not they also have their own, they have complied with tax obligations, whether they have done all these things. These are things that must independently be interrogated. So there's no, even in fact in our laws, there's no process by which one company writes and says, give my job to another person. Like, it is not even fathomable for that to be the situation. In fact, for me, this is the first time I'm seeing this happen.
Okay. They say that this first company that was engaged, they appeared before the board on 3 occasions. The last appearance was on August 16, 2024, during which fees for the audit and revenue assurance services were agreed. The board agreed, should be paid 16.5% of any excess revenue above the airport company's benchmarked revenue projections for its services. He sits at the board and supervises what the board, as it were, moderates the board's discussion. Vicky, because you wanted to come in, I'm still trying to appreciate what he would have done wrong, for which he will be the focus, and he will be part of those who are being investigated.
I'm also struggling having the same challenge because introducing someone per se is not an offense, but I guess it's how far you take that introduction and how complicit you are in maybe turning things around. In this particular case, DevNest, which is the company that appeared before the board 3 times and was then subsequently allowed to qualified as being the sole source company for this job, wrote. So if they are telling you they can't do the job, does that not immediately, isn't that a red flag? And then the people who can't do the job are recommending another company. So at that point, even if you hadn't done any due diligence at all, that should definitely be a point at which you say, okay, now where is this company? What is this company? Bring all your documents and dot your I's and cross your T's. And if you're talking about the board, then you should look at the whole membership of the board.
Right.
There has to be a reason why one board person, whether it's the board chairman or another board member, is being singled out. And I guess we will find out in due course why the OSP has singled Paul Adumotri out.
You see, as a board member, let alone a board chairman, you are a gatekeeper. You must protect the interests of the company. So when that company that won the contract, DevNest, wrote to the company, referring its activities to another company or transferring its activity to another company, that is the time that Paul and his board should have exercise their responsibility to keep the gate. At that point, they should have truncated that contract, terminated it, and then look for that other person to also come and do a presentation. Because that would have been the basis upon which they will now take them on board. But that wasn't done. So that responsibility of failing to keep the gate is where the board, and I agree, is the board. But we need to know why it's only Paul Adom.
Okay. But in fact, we can't say that it's only Paul Adom. I just want to be clear.
It's the board.
And we know that Paul has advertised his invitation. That as to whether or not the OSP is looking to talk to everybody on the board, we don't know that in fact.
They have told us that he's not the only one.
Yeah.
The OSP says he's not the only
On
one.
the board or just generally in the company?
We know they've named
We know
other
there are
people
others
who
in the company.
are part of
Yeah,
whether
but
they
not
are
the board.
They are board. I think they are
Yes.
not part of the board. Yeah. Okay. So as I understand it, the fourth estate is not the complainant in this case. It does appear that the OSP in its own investigations around SML chanced upon this and began to do its work. That's the impression I'm getting. How about the process? Let's begin with you because you are concerned about he being invited.
Yes.
And he says, you want me on a Thursday afternoon. My lawyers are in a Kumasi. Can you allow us to come on Monday? And I'll be frank with you. If a client of mine gets invited to police on a Thursday or Friday, I try to negotiate so they don't go because things can happen.
Yes. So just a bit on the issue we just left off. I can see that we are all struggling to know the legal vehicle that makes a board chairman solely responsible for.
We're all not struggling. Oliver was very clear about it. I think Vicky did, but posted a caveat.
So that
And of course, Abraham said, you are a gatekeeper.
Yeah.
So we are not all struggling.
so that the responsibility is placed at the doorstep of only the board chairman.
In
The
this case,
exclusion of
not
other-
only the board chairman.
But we've not heard any other board member who has been invited. In fact, not even the managing director who actually signed these documents for and on
so
behalf.
let's wait and see.
So maybe I may just have to,
noted, yeah.
maybe I may just have to restrain myself.
As we understand, the managing director is also appearing
Invited, has-
OSP. I think that's on Monday, rather.
Yes, exactly.
We'll go on Monday.
Yeah.
Very well. Now to the
But
invitation.
they have clarified that she's being invited, but she is not a suspect. I think I saw a clarity like that.
Oh, they said that?
Yeah, I think
She's
so.
invited as an
signed
interested
the-
party.
Maybe that's also an
yes,
issue
that's a
to
good
look
point.
at. That's also an
That's
issue to look at.
interesting because she signed
Yes, she did.
Yeah.
and she gave the directions, award the contract,
Yeah.
do this,
So it's
swap
about
the name.
the procedural matters that you have concerns
Yes,
about.
I
So we
think
do that
that-
very quickly because our time is almost up.
Of late, attending the invitation of investigative and security agencies has become a problem for lawyers and invitees, accused persons, so to speak. And it is because over time, certain conduct is more or less crystallizing into the state of affair. And for which reason, lawyers are also very apprehensive when on certain days at certain times when your clients are invited, you become very uncomfortable. In fact, I think
Because
that
bail is discretionary.
it is.
Even though we are entitled to it, it is discretionary. So the one who is going to give it may not give it, and they will
That
not
is
break any law.
That is true. That is true. And I think that at this stage of our democracy and even our legal system, I think we've come a very long way, such that if a jurisprudence that is as old as time, like the grant of bail, which is also one of the commonest applications you will find across all the courts in the country, litany of pronouncements on it, and of course with the
So
incremental
bring your
additions done.
own landed property.
Yes,
They don't put any value on it. That is the problem.
yes. I think that is new to our jurisprudence in terms of the
Is
grant.
that new to you?
Yes.
Oliver, is that new to you?
The requirement to produce property in your own name.
Yes.
Yes, it is.
It is.
I think so.
Okay.
Because I'd say that, the bail process is designed to have sureties in the process so that if you're not able to meet it, somebody else can. But then to arrest anybody without knowledge of what they can
There's
produce.
self-recognizance bill.
Yes, self-recognizance bill does not require you to produce
Any
property in your own name. Okay, so I think it's new, but I think that particularly in this context, But I think that the OSP was entitled to his 48 hours. And his decision within the context of that 48 hours to release Paul on bail was his decision to make within the context of that. Now, he then could, because the law is that you can release the person with or without conditions. He determined that the conditions, these were the conditions that were to be able to produce. His determination that the condition was demanding is that the property has to be in Paul Adumotri's name, for me, was a strange one. But the fact of the conditions of bail itself is not entirely new.
Okay.
I mean, there are instances where I've seen the demand for people to produce government workers.
Yeah.
In Nigeria, this has been found unconstitutional. We continue to do this in Ghana. So there's a bigger questions of reform of bail conditions generally.
Atabedu, we mentioned earlier, says that the procurement expert says that this issue has multi-facets of challenges. One, violation of pre-qualification, procurement methods, and engagement of consultants, provisions of 663. Contract law, several vitiating factors come to play, i.e. capacity to contract, fraudulent misrepresentation, corporate governance. There is obviously undue influence and the adherence to acceptable practices. Institutional capacity, both the boards of PPA and GACL were negligent and incompetent, and they must collectively be held accountable. I'm sorry, but we had extra time, but we have used that extra time. Thank you, gentlemen and lady. Victoria Bright is international corporate lawyer and entrepreneur. Paul Admotri sent me a message. It's quite very tall, but he's trying to explain that there's a lot of loopholes that you need these assurance methods to plug at the airport. And from the message, he suggests that if we're able to do this and do it well, the money we get from this place alone may be the reason we may not need to go anywhere borrowing money. So that's just to say, and that some journalists and other individuals get sponsored to work against this kind of, tightening the loopholes, and we should be careful about that. Okay, Abraham Amaliba is Director General of the NRSA and member of NDC Legal and Communication Team. Kwabena Boateng is MP Ejuso and Deputy Ranking Security and Intelligence Committee of Parliament. Oliver Bakavomo is Constitutional Rights and Policy Strategy Advisor, Democracy Hub. They are doing a protest on the Galamsey menace in September. The date again is 21st. I'll join because this existential threat, we must overcome it. This has been Newsfile. I'm Samson Ladia Yanini. Have a good afternoon.